sexual harassment against women at the workplace is once again center stage, with several accounts emerging of the most eminent of workplaces, not lacking in its in the basic minimum required to address internal complaints. And which brings us to the point, to the question, why is it that 5 years later, after a law was enacted, and several decades after the Vishaka judgment itself, are the workplaces still not complying with the law? So in this backdrop, there are a couple of issues I would like to highlight, which I think are of value to remember. One, that the law really at best touches, makes equal opportunities, provides a guarantee of equal opportunities through the sexual harassment law to women in organized sector workplaces, where the internal committees must be constituted. The unorganized sector, by and large, despite aspirations, have remained terribly neglected, because there is just no application of a good, strong, robust labor law regime in the unorganized sector, where the majority of Indian women are employed. So coming back to the organized sector, where at least there is a possibility of compliance, we find that under the law, the employer is meant to carry forward 4 obligations. One is of putting in place rules which are to prohibit sexual harassment explicitly. The other is to provide for a redress to complaints that come up, and that requires constituting a committee, an internal committee within the workplace. And the third is to prevent, and I'll come to prevention later, which is a key obligation which remains completely neglected as far as from what I see. And the fourth is to report annually to the government. Now, if we look at what is happening, is that in my experience, and I have interacted with a large section of educational institutions as well as private sector and government, at best what people have is a policy and an internal committee. That is at best, as I say, because it's not as if all workplaces still have a policy or have constituted their internal committees. So to the extent that they have these policies and internal committees, they have taken their steps towards complying. But unfortunately, what this means is that until a complaint happens, there is no preventive steps undertaken. And if preventive steps are not undertaken, then there isn't enough of an enabling environment for women to complain. And that's one of the biggest reasons why women who even are in workplaces with an internal committee stop from complaining, because they don't have the confidence to complain. When they do complain, the complaint has to be within 3 months of the last incident of harassment, and at best it can be additional 3 months if they give reasons in writing as to why they could not complain in 3 months. So that's the law as it stands, and within that time period is when a complaint can be registered as per the law. Some of the workplaces have taken a much more flexible sort of approach, because they ought to really have had these mechanisms earlier, but they didn't. So it is fairly ad hoc in terms of how workplaces approach older complaints. The other is a question that is often asked is, so who is an employer? An employer is essentially anybody who has people employed either on salary, consultancies, doing voluntary work, internships. It can be a university, it can be a college, and every unit, separate unit, is considered a separate unit for an internal committee if that unit employs 10 or more people. So that's as far as the redress obligation goes. It has to be unit centric if the unit has 10 or more people. And I find that again, organizations are fairly unclear about this. They have a head office where they have an internal committee, but they don't have it in their units because they don't think it's viable, and often they assume that there is never going to be a complaint. And I also hear about this sense of confidence that because they have a committee and they've never had a complaint, it's a very robust workplace. So which takes me to the point of prevention, that prevention essentially means that you create an environment where your staff, and if it's a university, your students and your staff and other employees would know of the value of having a law on sexual harassment, would know the basis of this law, which means to understand gender inequality, to understand how sexuality is constructed, both in terms of masculinity and femininity, and to be much more self-aware in how they conduct themselves. What we usually see is these little 2-hour gender sensitization programs, which I'm afraid are not enough. Often they're once a year for one batch of students. Again, simply not enough. If we see the deficit that we are up against, if we are really looking to prevent what is unfolding before us, it is a very normalized behavior. And this normalized behavior needs to be, interventions need to aim at re-socializing, not just addressing a misconduct as and when it arises. And I think in terms of doing that, one of the biggest deficits or gaps we see is institutional abdication in schools in terms of comprehensive sexuality education, and as well as in colleges. If schools have not done that, certainly colleges, I would strongly argue and urge that colleges take that up, not as part of that 1-hour, 2-hour session on sexual harassment at workplace, but as a necessary program which everyone goes through, because young people simply, and that's when they're curious, that's when they're learning, that's when they're asking questions, have no one to tell them how to do things right. We use the word consent very frequently. I'm afraid in my experience, when you talk to people, people don't know what doing consent means, what agency means, how to cope with a situation of rejection, because we don't have enough guidance in society. These are seen as failures. These are seen as, damning of one's personhood. And until we begin that conversation where we re-socialize people, normalize sexuality as a normal human urge, attraction, validate that, and basically guide young people on the ropes of what they can and should do or should not do, I'm afraid that transformation will not happen. Now, of course, we can't just rely on what happens in schools and colleges. We're talking about the workplaces as well. I haven't seen many workplaces with preventive tools such as codes of conduct. We strongly, at least in all my work, I do advise people to put together a code of conduct which gives people cues. People simply have learned to do what they do with a level of confidence that is too late to address through a punitive intervention at the end of the day, because people are getting hurt in the long run. You want to change that as an employer. You want to put down very clearly the do's and don'ts of social interaction. You want to say that how much alcohol is okay on your premises, how much is not. And if it's something that you're not willing to take a stand on, are you willing to appoint designated non-drinkers? Are you willing to take responsibility for what happens in your premises, what happens during field trips, what happens when young people go into the field and interact with senior officials, state officials? Because I've heard a lot of stories which show the fault lines in exactly these situations, and unless we sort of robustly respond to these with a set of prior guidelines, I'm afraid we are only going to rely upon redress and punishment as the only way forward, which is not at all, to my mind, something that would transform in the long run, but is nonetheless absolutely important.
To receive instant updates on all videos from The Wire, click the subscribe button and hit the bell icon. Pay to support independent journalism. Click the link in the description and choose the amount you want to pay.